Ladies,
Campbell.
my lords, just before the short adjournment, I had almost completely finished ground one. The last point I was going to make was actually also my starting point, just to remind the court of the words of Lord Hoffman, Kieran Amgen. The question is always what the person skilled in the art would have understood the patentee to be using the language of the claim to mean. And that's set out as is Virgin Atlantic in my skeleton at Paris 15 and 16. Moving on then to ground two, which is the diverter valve configuration. The judge set out the competing constructions, judgment Paris 77 to 78. I'm not sure we need to go to that because my own friend's position is quite clear. He says the achievement of the substantially unchanged flow rate during the changeover is solely due to the configuration of the diverter valve itself. So he therefore focuses on the flow through the diverter valve.
She.
I'm sorry?
The judge.
Yes.
She.
The judge, it's on Paris 78.
Yes.
Of the judgment, it's page
So you're referring to Mr. Nicholson's submission?
Yes, it's just setting
okay.
out Mr. Nicholson's submission.
Thank you. Got it.
It's right we should go there, and my lady and my lord should have particular regard to the word solely due to the configuration of the diverter valve itself, so the key words are solely itself. Now, I'll make a number of submissions about this, but their submission, taken at the starting point, is that even though the user of the apparatus only cares about the result of the flow through the entire apparatus, the Triton's argument, the appellant's argument, is that only flow through the diverter valve itself matters. That's why they say itself and solely. Now, that would be a classic example of something falling within the patent. I accept that. But the patent never itself says it must be the construction of the diverter valve alone which achieves the desired effect. And the desired effect is the flow rate is substantially unchanged during changeover. So the key point, obviously, is what's meant by diverter valve is configured so that. We've already looked at the remaining parts of this characterising into the flow rate is substantially unchanged. But what does configured so that mean? Now, my Lady Justice Falk said correctly, and would respectfully agree, that you've got to know how the water goes through the claimed apparatus. In fact, we would go a little bit further than that by reference to something that the judge said, and indeed found to be common general knowledge, at an earlier part of the judgment. And I should show my lady and my lords that earlier passage.
Well, just before you go on, can you explain? Because what my lady actually said was that it was implicit in the claim that there is a supply of water, which is actually a bit different. She didn't say you've got to know how the supply of water
In that case,
flows through.
I apologise, I misunderstood, but I'm going to make
and to be clear, Mr. Nicholson accepted that it's implicit in the claim that there's a supply of water.
Yes.
Or rather, that the heater of claim 1 can be connected to a supply of water. I think that would be more accurate way of expressing what he accepted.
Yes.
But can I, and perhaps it may be helpful if I just try and rephrase the question by reference to what the judge said, which is paragraph 78. And she poses this question: how could the skilled person look at such an assembly on a shelf with no water collection and assess whether the diverter valve is configured so that the flow rate is substantially unchanged? Now, do you defend that as a correct approach to the issue?
I can't entirely defend it, no, for the reason I'm about to explain. And the reason I'm about to explain, and my apologies to Lady Justice Falk if I've inadvertently put words in Lily's mouth, that wasn't the intention. If I could take the court back to paragraph 44.3, 44 Roman 3 on page 118 of the court manual. It's something we saw earlier. It's agreed findings about common general knowledge. The experts agree that there were three main factors affecting the outlet temperature of electric shower. And 3 is the flow rate of water over the heating elements. And it goes on to say this was controlled by the use of either flow stabilization valve, and this link between flow rate and temperature being widely appreciated, etc. But it's really the first word, the flow rate of the water over the heating elements. If one's asking, well, what is it about the environment which matters? What is it about the configuration that matters? You have to consider the flow rate of water over the heating elements.
I beg your pardon, I'm struggling to understand this. When you speak of the environment, what is the environment to which you are referring?
Oh, the environment the diverter valve itself is in.
Sorry,
The environment the diverter valve itself is in.
Sorry, are we talking about something beyond claim 1?
Slightly more, yes. Because the diverter valve is in an instantaneous water heater as per claim 1. Yes. But if you want to consider how the diverter valve is configured, my submission is it's broader than just looking at the construction of the diverter valve itself. You're looking at the effect on the whole system of the flow rate of water over the heating elements.
But you refer there to the whole system. What is the system when we're looking at claim 1?
Claim 1, instantaneous water heater of claim 1.
Right.
Using the word system and as a shorthand way of referring to claim 1. So it's not just how the internal construction of the diverter valve that matters when it's talking about is configured.
I'm sure it's my fault, but I'm struggling to understand this because the instantaneous water heater of claim 1 has 2 components and 2 components only. It has a heater tank,
yes,
and it has a diverter valve. That's it.
Well, it's got at least 2 outlets, yes.
Sorry, all right, fair enough, yes. I take that point.
Well,
three components if one takes the 2 outlets together, yes.
Yes. Yes.
But nothing more.
But if you're asking yourself, well, how do you know if the diverter valve is configured so the flow rate is substantially unchanged? My submission is it's wider than just looking at the internal structure of the diverter valve. You look at the effect of the diverter valve on the flow rate of water over the heating elements, because that's what it's meant to affect. So to go back to my Lord Justice Arnold's
All right, but I'm still struggling to understand your answer to the question that I started with, because the question I asked was whether you were defending the judge's approach, and you said not entirely.
No.
So you've talked about the environment, and I'm still a little unclear on that. You also talked about the system, and you've defined that as being the system, meaning the components of the instantaneous water heater, the heater tank, the diverter valve, and the outlets, and of course implicitly there has to be an inlet as well, I suppose. But you still seem to be submitting, if I've understood you correctly, and if I've misunderstood, please correct me, that the word configured, takes you somehow outside the components of the word of the instantaneous water heater. Is that your submission?
Well, my submission is that the word configured, to determine how the diverter valve is configured, you have to determine its effect on the flow rate of water over the heating elements. That is part of its configuration. It is not merely the internal construction of the diverter valve.
Yes, but I'm struggling because I'm not understanding that that's an answer to the question I was asking, and it may be that that's my lack of understanding.
Well, I can go back to paragraph 78.
But you make the point, which I do understand, that it's not just about the diverter valve. I've got that. But the question I was asking was, does it take you outside the instantaneous water heater, that is to say, heater tank, diverter valve, inlet, outlets?
Well, it can't take you outside that because that's defining the universe. But it does require you, by submission, to consider, as I say, the flow rate of the water over the heating elements. Now, the heating elements are part of the heater tank. And the reason you have to consider water and water flow is because that's the whole point about flow rate substantially unchanged during changeover. So you obviously have to consider the heating elements, because that's the heating. You obviously have to consider the flow rate, because it says configured, so the flow rate is substantially unchanged. And what's important about the flow rate is the flow rate over the heating elements, because that's what gives you the risk of scalding, undesired temperature, and so forth. So the word configured does require you to consider these things.
Let's just proceed on that basis and take us through what you've just said. When you look at this, how does it actually meet claim 1? Because if I'm just looking at this diverter valve and the heater elements, the inlet and outlet, how does it do what claim 1 describes?
Well, claim 1 isn't just to a diverter valve, it's the heater of the three components. And the diverter valve is configured in a particular way. So my answer to that question is, well, you've got to see how the diverter valve is configured, not just what its internal construction is.
Yes, but the appellant's point is that this particular one is configured that the flow rate will reduce significantly.
Well, that depends if you assume configuration is indeed what their argument.
Well,
solely determined.
As I understand it, the flow, unless the flow rate is at the minimum, is so low that it won't be affected by the apertures being at 34%, then
that's precisely the point on infringement.
So you have to make an assumption that it's at 34%.
No, you don't make an assumption. It's actually set out in the product description and the cross-examination of Mr. Murray. When we get to, jumping ahead, when we get to infringement, I'm going to say it's not just the risk of scalding that's the infringement. There was the marketing literature, there was the product description, in particular paragraph 14, and also the cross-examination of Mr. Murray on this subject, which is quite brief.
Yes, but I'm still struggling because part of what you say I understand very clearly. You say, and this is very, very clear, you say it's not just about the internal construction of the diverter valve. Yes. That's clear.
Yes.
But I'm still struggling to understand your answer to my question. That when we look at the word figure, configured, does it or does it not take you outside the heater tank plus diverter valve plus inlet plus outlet? I think you must say that it does, because otherwise I don't understand how you get home on infringement.
Well, yes, it must do, because, as I say...
In which case, how do you ever judge whether this claim is infringed when you look at a water heater on its own?
Oh, it's quite simple. You consider the flow rate of water of the elements and see if you're always going to have a real system of which the diverter valve is only part. You're always going to have a real system which has a heater tank, the diverter valve, and the two outlets. And you would have to be able to say...
So how do you judge infringement on the docks when there's importation of a water heater?
Well, you look to see how the product works, just like we did in this case.
what's the product to which you're referring?
I'm sorry?
What is the product to which you are referring?
Oh, the
Say,
Durelec
see
electrical
how it
shower.
works.
I mean, in this case, what we had was we had...
No. I'm sorry. I'm obviously not making my question clear. I apologise. So you have a water heater component on the docks, and you are exercising your rights as patentee, pursuant to this claim, to stop importation by a border measure. How did the customs people know whether to seize the goods or not? Because on your submission, as I understand it now, you say the word configured takes you outside the components of Claim 1. So how does one judge the question of infringement on the docks?
Well, the answer is you do have to require knowledge of the configuration. It may just be like the general purpose computer.
So what that means is that sometimes it infringes and sometimes it doesn't. This
no.
is Schrodinger's water heater.
No, if you know it's configured or intended to be configured for use in one particular way, that infringes. If it's not so configured, it doesn't. So the same thing might infringe or not infringe, but it depends on how it's configured. And if I'm right that it depends on how you're configured, and you don't know how it's configured, then you don't know if it infringes. It doesn't mean it's simultaneously infringing and non-infringing at the same time. It means you've got insufficient information to know whether or not it infringes, because you don't know how it's configured.
Okay, now I think I understand. Thank you.
I mean, there are other claims. For instance, Claim 5 has spray fittings. So you can work through the claims and develop further.
Are those ones all said to be subsidiary?
No, not Claim 5. No. Sorry, it is a subsidiary claim, yes, because it's a subset of Claim 1. It's not said to be independently valid. If that was the question.
Sorry, I may have used the wrong words, but I think that's what I meant.
Okay, now that's my submission about what that means. Can I now show what I mentioned a moment ago as to the evidence on infringement? Now, it's not as simple, and we'll see that neither in the judgment or in the evidence is it a matter of, well, they just admitted it, they didn't scold the customers, and that was that. I'm going to start with something which I don't think my ladies and my lord might have seen before, but that was a product description, and that's in core bundle at tab 23. And this is mentioned in the judgment. I'll go to where the judge deals with this. There's a particular paragraph in here that's important, but just by way of background, if my ladies and my lord have got at page 249, para 1, it was served pursuant to directions order, and para 2 sets out what it was required to cover. The defendant will provide a product description together with, if appropriate, relevant drawings and images describing all components that influence the flow rate and or risk of scalding during changeover from one showerhead to the other of the products alleged to infringe, each of them to the claimant by no later than 1st December 2023. Now, the heater needn't detain us, which is the first section. And the diverter valve, well, we don't need to spend time on it because it's in the judgment anyway, in particular the diagrams, and my ladies and my lord have seen a sample, so we'll come back to that. But the reference to the flow stabilisation valve on page 252 is worth a look. And paragraph 14 says the flow stabilisation valve controls flow rate through the shower by varying the size of the cross-sectional area of the water flow path. The smallest cross-sectional area of the flow path within the shower system is situated between the flow regulator and the regulator membrane within the flow stabilisation valve. So that is the smallest cross-sectional area of the flow path within the system. So it's within the flow stabilisation valve, it's not at the diverter valve. The rest of that paragraph didn't particularly concern us. But just pausing with para 14 before we go on to para 15.
Sorry, can I just check I've understood that
Yes.
point? So that's an additional way of changing the cross-sectional area.
No, it does say the smallest cross-sectional area of the floor path within the shower system. It doesn't say that's an additional cross-sectional area.
Sorry, we may be at cross purposes. Are you disputing that the diverter valve changes the cross-sectional area? I thought you weren't.
Well, no, I am disputing it because it may change cross-sectional.
Well, how can you? Because
if I could just finish the answer to my Lord's question, it goes from down to 34%. Yes, but that's never the smallest cross-sectional area of the floor path within the shower.
yes. So I go back to my question. Your point is this is additional. Yes.
Well, it's an additional way to vary the flow path within the shower system, yes. But the smallest cross-sectional area is the flow stabilisation valve. What this diverter valve must be doing is it's not the smallest cross-sectional area.
Yes, but another way of putting that is that in this design, you don't have a diverter valve problem to solve because the flow stabilisation valve has restricted the flow to such an extent that there won't be effective flow restrictions using the diverter valve because it's already down to, if you like, 34% or below. If I've understood it correctly.
Put another way, taking the cross-sectional area down to 34% of the diverter valve doesn't make a difference.
But that's because
Yes.
it isn't the diverter valve itself that's not affecting the flow rate in use. It's because there's something else.
Yes,
Outside
something
the
else
system.
affecting it instead.
Outside the system that's the subject of Claim 1.
Well, the flow stabilisation valve isn't expressly mentioned in Claim 1, that's absolutely true. But it's still part of the defendant system. So what they've done is essentially they've got a diverter valve which can take the cross-sectional area down to 34%, but it doesn't matter. And I think this is my lady's point, because something else, the flow stabilisation valve, is the narrowest point in the system.
I'm, as you all know, I'm not an IP specialist, but why should a patent protect or allow a monopoly in relation to someone who's come up with a different solution?
Well, I think the two answers to that is, firstly, is this still within the scope of the claim properly construed, in which case it's not a different solution, it's still within the scope of the original language. The second answer would be pursuant to the doctrine of equivalence, and I have a live point on that as well.
Okay.
But I think what the lady's saying is, well, it depends what you construe the claim to mean in the first place.
That may,
Yes.
that may be a ground 2
Yes.
point.
But the point of simply on, there may actually be no misunderstanding here, I may just be explaining it quite badly. But the point I'm trying to get across is that, as para 14 says, the smallest cross-sectional area is in the flow stabilisation valve, which is why going to 34% makes no difference in practice.
Yeah.
And one get, and that's not altogether unreasonable, because if the flow stabilisation valve wasn't at the narrowest point in the system, the bottleneck as it were, how could it control or stabilise the flow anyway? It's got to be there. And then reading on in 15A and particularly B, 15A, well, the flow stabilisation valve's got two functions. The first one doesn't particularly matter. You can just make a manual adjustment which does change the cross-sectional area of the flow path through the flow stabilisation valve. So you're just getting more water through by a manual adjustment. But there's a second effect, which is it continuously regulates the flow rate anyway, regardless of the manual adjustment. And B1, if the pressure increases, in other words, too much water coming through, it will reduce the cross-sectional area, decreasing the flow rate. And then conversely, the pressure decreases, so there's not enough water coming through, then it increases the cross-sectional area and hence increases the flow rate.
So the flow rate is being dealt with by the regulator membrane, which is part of the flow stabilisation valve.
Correct, and it always is. There's no suggestion that the flow stabilisation valve, if it ceases to be the smallest cross-sectional area of the flow path. And if it did, then it wouldn't work anyway. The thermal cutoff wouldn't take us particularly long because that's just, well, it has stage 1 and stage 2. I'll just show my ladies and my lord it. If quote was page 254 of the bundle, stage 1 cutoff, the thermal cutoff triggers at set temperature of 55. Oh, it's getting rather hot, it automatically cuts off, but then it automatically comes back on. Stage 2, oh, it's got really hot now, it's got 80 degrees, there's probably a fault, and it's cut off permanently. Now the judge deals with this at paragraph 137 on page 156. And I've just actually gone through the product description, which the judge then summarises at 137 and 138. And the judge deals with the admission at para 140, the judgment next page, page 147, but doesn't stop there. The judge then goes on to have some nice diagrams of the same model that my ladies and my lord have had, and the famous diagrams, which are the sort of the 34% figure. These were taken from the product description. At 146, the judge actually accepts Triton's submission because the shapes of the port of the flat is not a linear and gradual progression from port A being open to port B being open with the same cross-sectional area and so on. Instead, they accept the combined cross-sectional area open outlets varies significantly during changeover, as can be seen in the illustration above, so at one point it's only a third of the area of a fully open outlet port. So the judge is well aware of the point that is being made. And then the judge deals with the evidence at 147 and 148. Now, 147, we've actually got a copy of this evidence to hand up if necessary, and I will do if necessary, but I'll summarise it just to perhaps avoid that. The evidence being discussed at 147 wasn't with reference to the product description or para 14 thereof. It was very general about just where the minimum cross-section area might be generally, which is why it's not surprising there's no reference to the product description or any of the marketing literature we'll come to in a minute. But para 148 is a summary of some evidence. Now, it's actually quite short, and I would like to show the court this evidence. That evidence is just a minute. It's core bundle 21. Sorry, that's the wrong reference. It's supplementary bundle. Just I'll leave them alone, give me a minute. I'll just make sure it's the right reference. Yes, sorry, it's supplemental bundle, tab 9, page 81. It's quite short, just a few pages, and it is summarised in that paragraph. And this is what the evidence actually was. Now, if the court's got to page 81, at the bottom right, it's page 175 in the internal numbering. And this is where I start cross-examining Mr. Murray on infringement. And as can be seen from line 3, I was guillotined to 15 minutes. But this is how I used the 15 minutes. I'm going to ask some questions about infringement, Mr. Murray. And then he doesn't see any reason to distinguish between the products. Is that right? Yes. 12. Okay, I'm going to use the general term dual electric showers a dual electric shower and dual electric showers talk about alleged infringing. You know what I mean? Yes. Would you accept that when the user operates the diverter valve, the dual electric shower seamlessly diverts between the rainfall and the shower head? Yes. I'm not sure if my ladies and my lords saw that bit. We did flag it up. It's a bit of their marketing, which actually was exhibited. Well, I'll show it later. But it's part of their marketing where they talk about seamlessly diversion. Then that takes us to the PPD, which I've just taken the court through.
Can you help me on this?
Yes.
Did you anywhere explain to the witness what the word seamlessly was supposed to mean?
No, I took it straight from the defendant's marketing.
To be sure, but is it your submission that the meaning of the word is self-evident? And if so, what is that self-evident meaning?
Yes, it is self-evident, without a break.
And what does it mean?
Well, it means without a break, but without a detectable difference. Without a seam would be the literal meaning.
So without a break and without a detectable difference.
Well, I can...
A detectable difference in what? Because I observed that in your question, there's no reference to pressure, there's no reference to flow rate, there's no reference to temperature. So when you say without a detectable difference, what does one understand that the witness understood?
Well, the witness...
Without a detectable difference in what?
Yes. Well, I'll answer the question by showing what the basis of the question was. Because
Well, at the moment, you're relying upon the evidence of the witness, which,
yes.
and since you got a yes to your question,
Yes.
that's fair enough so far as it goes. But what I'm trying to understand is what we get out of this. Because the witness answered yes to the question, fair enough, but what does the question establish? And it depends on the meaning of the word seamlessly, which is, what do we understand that the witness understood the word seamlessly to be referring to?
Well, that's a fair question. I should show the source of this question.
But unless you showed the source to the witness, how does it illuminate? Did you show the source to the witness?
No, but it was mentioned in the expert reports and the skeleton arguments. I anticipate that's why he wrote as readily as he did. But even if that's wrong, I will show my lords the place where the statement was originally made by the defendant.
Fine.
And that's Core Bundle tab 14, page 187. This was actually annexed to the particulars of claim as IPREC procedure, so it was in the case from day one. And it's the defendant's marketing for the ND electric shower with dual shower kit silver, which is one of the alleged infringing products. And then towards the bottom of the page, there's a number of features. Discover the next generation of personalised electric shower ND. There's a number of features, the third of which is Dualex seamlessly divert between luxurious rainfall and a 5-spray pattern shower head. So that was the source of the seamlessly divert.
And your submission is that the word seamlessly in that context means what?
Well, the same thing, literally without a seam, but without a break or change in temperature.
So now you say it means without a change in temperature. And how do we know that?
Well, I think it's a question of what else does seamlessly mean? I mean, it's they didn't. There was no one else I could cross-examine at trial about this because there was Mr. Murray who was the evidence on infringement.
PPD signatory.
Yes, I suppose I could have asked the PPD signatory, but this isn't the PPD. It's the marketing material. It would have been open to the defendants to say, well, if that doesn't mean what you say it means, they could have adduced evidence saying...
Yes, but that's a fair point so far as it goes, but what I'm struggling to understand still is how the witness was supposed to understand. First of all, you didn't put the document to him. Secondly, you didn't define your understanding of the word seamlessly. So, yes, the witness answered yes, but how does that assist us? You didn't put to the witness, and that means without a drop in temperature or an increase in temperature.
That's true, and I didn't put the document. That's because I got the admission yes first time. The Lord correctly points out that I didn't. I took that. This is the question and answer. That's what it is. The rest of the cross-examination then goes on to. I mean, he didn't say, I don't know what you mean by seamlessly convert. I think I could legitimately say that, and since it's been part of our plea the case all along, that would be surprising. But it is true, I didn't define what I meant by it. Now, moving on to the next page, though, page 176 of the internal numbering. It'll be seen there, put to Mr. Murray, the description of the flow stabilisation valve, in particular paragraph 14. That's at line 6. And I also draw, as one reads on, I'll try and do this relatively quickly, if one looks at page 177 of the internal reference, I read out the relevant sentence from paragraph 14. Then at paragraph 15, I put it away as you accept that since this is the smallest cross-sectional area of the flow path in the shower system, this will generally determine the rate of flow in the system as a whole. Yes.
I'm sorry, it's my fault. I've lost the place. Can you give me the reference again?
Line 18. Yes.
177. 177.
Right, okay, thank
50.
you.
So I've just read out 15 to 18. And then let us consider an area flow path in the shower system, particularly an area with a larger cross-sectional area. To make it clear, this one here I'll call area X. And then I make it clear that I'm now thinking of another area of the flow path through the shower system, a larger cross-sectional area. I'm calling that Y. Doesn't matter if area Y is upstream or downstream X. Let's assume it's downstream. You accept because area Y is a larger cross-sectional area than area X. Area Y does not determine the flow rate through the system. Yes. If we were to reduce the size of area Y by 66%, whether that makes any difference to the flow rate through the system as a whole depends on whether we've thereby reduced it below the size of area X. Yes. There's some questions about the diverter valve. And then lines 18 to 21. We know the reduction in cross-sectional area you mentioned, that's about the Triton diverter valve, doesn't interfere with a seamless diverter between outlets, does it? It would appear not. And then I go on with a little bit more in the PPD document. We don't have to read the rest of it. Now, the reason I've drawn attention to that is actually the evidence referred to by the judge back in the judgment. At para 148. The judge said Mrs. Murray also accepted in cross-examination the dual-electric range, dual-outlet electric showers seamlessly direct from one outlet to the other. I've seen this claimed as a feature in Triton's marketing literature, and that's the marketing literature that shown to my ladies and gentlemen. And then just reading out the rest of this, well, the lady in Kohler can read it, but Mr. Mills agreed reduction cross-area of the diverter valve didn't interfere with the seamless diverter outlets, accepted the flow stabilisation valve generally with narrowest points and so on and so forth. No reason to suppose that the dual range showers did go outside normal electric parameters. And he accepted that if substantially unchanged was construed in reference to the risk of scalding, construed the diverter valve alone and the diverter valve together with flow stabilisation valve were merely two different ways of achieving the same result.
Sorry, I'm afraid I've struggled to understand the judge's reference to the diverter valve alone. Because, as I understand it, it's really the flow stabilisation valve that's doing the job.
Yes, well, in this system they were working together, yeah. Well, perhaps I could answer it like this. I mean, in the alleged infringing system that we're considering here, there never is a diverter valve alone. It's only ever part of a system in connection with the flow stabilization game. So it wasn't just a matter of, well, they don't risk scalding. There was the additional evidence which supported the judge's conclusion, I would respectfully say. I haven't been to 149 to 151. I don't think it's necessary to do so. What I would like to do now is say a bit about the argument of infringement on the doctrine of equivalence. And it really depends on what reason. If we get this far, then I must have lost on conventional infringement. And because there's two separate issues up, it's not clear which of the two issues I would have lost. But there's no dispute as to the law. It's as set out originally in Actavis and Icescape and Ice World International. It's all set out with the skeletons. And we only get here, as I just said, we've lost on normal interpretation and infringement. So it must, we're now looking at something else. And there are three questions you have to consider. My learned friend outlined them. And your lordships are not, ladyships and my lord are not troubled by questions 2 and 3. It's just the first one. And the first one is, notwithstanding is not within the literal, i.e. normal meaning of the relevant claims of the patent, does the variant achieve substantially the same result in substantially the same way as the invention, i.e. the inventive concept revealed by the patent? And I think I remember my learned friend saying he didn't dispute substantially the same results, but he did dispute substantially.
That's on the hypothesis that it's avoiding the risk of scalding.
Yes, well, it only gets into this by various hypotheses, but he certainly put the bulk of his submissions into substantially the same way as the invention. But if the court has got this far, well, one has to decide, well, what is the inventive concept revealed by the patent? And that's often a rather difficult question, because what is the level of generality at which you answer that question? And we've set out in our skeleton arguments various case law approaches as to asking this question. One was by my Lord Justice Arnold at first instance in Acabian Fibrogen. What is the inventive concept embodied in the claim? In Edwards and Merrill, Mr. Justice Bursey then was, he identified the inventive concept for purpose of obviousness and used the same formulation for equivalence. What we would say is, and this is something I'll return to in relation to obviousness, the inventive concept arises from the realization that in the special case of a dual outlet electric shower, the diverter valve gives rise to a risk of scalding if it is configured so as to interfere substantially with the flow rate. And the inventive concept there is the idea or perception of that problem, coupled with a solution thereof. Now this overlaps to some extent with the submissions on obviousness, as occurred to Mr. Justice Burson, Edwards and Merrill. It depends what you think the inventive concept is. But it really depends on a question of generality. If the one thing and I don't want to repeat submissions already made about what the claims cover and what the clever idea of the patent is, particularly when I'm going to cover that anyway in relation to inventive step and my answer to the obviousness case. But if, as I respectfully submit, the inventive concept as we say it is, then they still infringe under the doctrine of equivalence because they are achieving substantially the same results, which is the avoidance of scalding, in substantially the same way as the invention. All they've done at most is add an extra component, but it works in the same way ultimately in that adjust the flow rate of the water from the heating elements to avoid the risk of scalding.
They have cut-off mechanisms too, don't they?
Yes, they do. I did spend a bit of time on the thermal cutoff. That seems to be a rather more for the fringe cases. The first stage thermal cutoff is when it got above 55 degrees C.
Yes, and the other was 80 or
And the other
so.
was 80. Well, I don't shrink from that. And okay, if I have to say they're part of the mechanism, I will say that as well. I did plead it on that basis. So it makes no difference to my case, I would say, whether I have to go to 2 or 3 components. They're still achieving the same result as the invention in substantially the same way, i.e. by adjusting the flow rate. Now that was all I was proposing to say about construction and infringement. Unless I can assist my lady and my lords further on that, I was proposing to go on to validity at this stage.
Thank you.
Now, so far as validity is concerned, there's 3 separate grounds. Invalidity for insufficiency on grounds of uncertainty, invalidity for insufficiency on grounds of breadth of claim, and obviousness of common general knowledge. And the first 2 are quite largely questions of law. That's uncertainty and the claim broadening. And I'm going to take just a little bit of time to look at a recent decision of this court, Aaron Casse, which actually considers both of these points. Although I'm going to say, having done that, the answer is actually quite easy. The law may be difficult, but the answer is easy. I don't know what the effect of hearing that on the court is. You may say, why don't you just give us the easy answer first? Well, the easy answer is, I'll rise to my own challenge then. The easy answer is, it's not invalid for insufficiency. At most, it's a fuzzy boundary. It's not uncertain, is the answer to the first one. Secondly, it's not too broad either. The claim broadening objection has only succeeded in a very small number of cases. But having said that's the answer, I'll now justify why I reach that answer. If I could invite my ladies and my lords to go to Casse at Joint Authorities tab 10. This may not be a familiar decision to at least 2 of the 3 members of this court. But it is a relatively recent and quite a helpful analysis of these 2 particular grounds of insufficiency. And the report starts at Joint Authorities 2, tab 10, page 477. But I'm going to pick it up at page 489, because the argument in that case concerned the words consisting essentially of. Did that mean that the claim merely had a fuzzy boundary, or did it mean it was conceptually uncertain? Now, I've picked up a claim 18, because that does actually, sorry, paragraph 18, because it does identify the relevant words consisting essentially of. But just to be a little bit fairer, I will show the whole claim, which is on page 487. It's not the first whole punch. And that was claim 1, a ceric oxide consisting essentially of a ceric oxide, and etc., etc. That's the whole thing. But the words we're worried about is consisting essentially of.
And this is the judgment of Lord Justice Floyd.
Yes, it is Lord Justice Floyd, with whom Lord Justice Peter Jackson agrees, and Lord Justice Merson adds a bit about the difference between a fuzzy boundary and a boundary whose location is impossible to ascertain. But yes, this is Lord Justice Floyd, and
but you really need to look at paragraphs 13 and 14 to understand the context.
yes,
It's not your fault.
No, I did wonder about that.
But there he explains in paragraph 13 the difference between consisting of and comprising, and points out in 14 that consisting essentially of is a hybrid. And he also records that the parties in that case were agreed that the skilled person would have regard to the practice of the EPO to regards consisting essentially of claims as meaning that apart from the mandatory agreement, in this case cereal acid, no other agreements are present which materially affect the essential characteristics of the product. So that was common ground, and one needs to understand that in order to understand the court's resolution of the issue.
Yes, and that is referred to in the first line of paragraph 18, notwithstanding the pleading agreement on what the claim means. Not a usual thing to agree on what claim means, actually, but we did in that case. Anyway, that's what the claim was, and as Lord Justice Arnold has explained, it's unusual in a number of different respects. It's totally different to the one we have here. But the argument was, well, it's still conceptually uncertain. Now, picking up at paragraph 22 on page 489, although there's only one statutory question of insufficiency, it's been found to arise in a number of distinct ways. And there's a couple of examples which are always given of insufficiency by reason of uncertainty. They're not the only two, but perhaps the most famous two. And one comes from Kieran Amgen, leading decision of the early years of this century. And it was claim 19, defined recombinant of erythropoietin, the red blood cell hormone, I think, protein, by the requirement that have a higher apparent molecular weight measured by a particular method than urinary erythropoietin. So the synthetic one is a higher apparent molecular weight than the urinary version. It's a naturally occurring substance. But the problem was that urinary EPO had a molecular weight which varied, and it varied depending on such matters as source and method of isolation. And not only that, they were hard to come by, in fact extremely hard to come by. So that was why the claim was conceptually uncertain, because you didn't know what your comparison was. Now, that was the first famous example. And picking up now at 24, used to be called ambiguity for historical reasons, but we don't call it that anymore. We call it uncertainty. And there's a reference at paragraph 25 to the judgment of Lord Justice Lewis, which I wasn't going to go to, but that's, I think, the origin of the word uncertainty. So anyway, that's one famous example. And another famous example is a case called Milliken, Denmark and Walkoff Mats. A property, it was actually a lie detector, which was required to be measured in Pinocchio units. And of course, the point is no one knows what a Pinocchio unit is. And that wasn't a question of a fuzzy boundary. You literally had no idea what a Pinocchio unit was. And these are by far the most famous examples of this. Now, the argument has succeeded in other cases as well, perhaps less colourful than those two. But the test is always, is there actual conceptual uncertainty? And we see, we don't need to spend too much time on the facts, but it actually failed in Alain Cassé, the argument of Neo, for various reasons, and we can see the reasons from paragraph 28. This is not a case where there's any argument about the criterion which one needs to apply, and it's just whether it has a material effect on the essential characteristics. Secondly, insofar as the defendant purchased not having access to process details, that was a false premise. But thirdly, and most fundamentally, and this is from paragraph 30, the suggestion determining whether a product was inside or outside the claim would impose an undue burden on the skilled person was not made out in the evidence. So the facts don't matter other than that it failed. You might have thought the words consisting essentially of had a sort of fuzziness about the meaning, but they weren't conceptually uncertain. So that's the test, and carrying on with this, the breadth of claim insufficiency was also considered in this case. And I'm now jumping ahead to paragraph 34, and I'll just run through the established points. There's one point I want to get out of, which is the explanation of Biogen in Lundberg. But in order to get to that point, I should give my ladies and my lord a bit of background. The relevant principles are set out, paragraphs 36 to 39, the burden of establishing the objection of the person attacking the patent, that's the learned friend, the appellant. Secondly, the specification must enable the invention to perform the possible width of the claim. Thirdly, this doesn't mean that everything would be infringed on the claim must be enabled. And fourthly, some inventions may be claimed in apparently broad terms, with patentee's invented general principle, which we expect to work equally, but also I'll just short-circuit components of the future. At the end of that paragraph, 39 is worth looking at. The objection's insufficiency is highly sensitive to the nature of the invention. And that point is certainly correct. Now, what was the claiming biogen like? Well, it was unusual in a number of respects, which are explained by Lord Justice Floyd here. Para 41 is the start of it, but jumping halfway down the paragraph on page 493, the principal claim at issue is to a recombinant DNA molecule characterized by a DNA sequence coding for a polypeptide or a fragment thereof displaying an HBV antigen specificity. This was a claim to a product, a molecule identified partly by the way in which it had been made, which was recombinant DNA, and partly by what it did, which was to express a polypeptide with HBV antigen specificity. Lord Hoffman explained at 40, this was a generalization Professor Murray had done in two ways. And the first way is generalizations to the results he achieved. And secondly, there was a generalization of the method. Now, the details don't matter, but the point in Biogen was there was a very significant generalization in these two ways of what the patentee had actually done. Generalizations to results and generalization as to method. You don't need to spend too much time on 42. And 43, it's really the bit over the page. The patent may claim results which it does not enable, such as making a wide class of products which enables only one of those products, and discloses no principle which will enable others to be made. Or it may claim every way of achieving a result when it enables only one way, and it's possible to envisage other ways of achieving that result which make no use of invention. Now, just pausing there, this last sentence, gave rise to a great deal of uncertainty in the profession about what the limits of it really were. Because how do you know when a patent is claiming every way of achieving a result when it enables only one way in such a way that it is too broad? Because quite a lot of patents, including the one in Lundbeck, are drafted in a particular way in which that objection might be thought to apply. But in fact, this statement of principle was, as Lord Justice Floyd says, considered further in Lundbeck. Because what they did in Lundbeck, I'm skipping to the end of paragraph 44, is Lundbeck undertook this research, which is into a particular, it's plus and minus enantiomers, a particular optically active drug called citalopram. Lundbeck undertook this research and devised a method for making the pure plus enantiomer, which was the established, the active one. So the research devised a new method. That's clear. They were the first to do so, and the claim to the pure plus enantiomer was held to be novel and not obvious. Now, just a straightforward application of what Lord Hoffman had just said was, oh, all Lundbeck has contributed to the art is the method. And that is the argument, my ladies and my lords, see in the first sentence of paragraph 45. Oh, all you've actually done is one method. You could use other methods to make it, including high-pressure liquid chromatography. Therefore, your claim's too broad, because if we just apply Lord Hoffman's observation from Biogen, your claim must be too broad because these other methods owe nothing to Lundbeck's method. But the argument was actually rejected by the Court of Appeal, which included Lord Hoffman as an additional judge for that, and by the House of Lords. The flaw in the argument is that it was wrong in the case of claimant issue in Lundbeck to define the patentee's contribution by reference to the inventive step rather than technical contribution to the art. Now that might sound quite a subtle distinction, and in some ways it might be considered to be exactly that. But the point was, you've got to decide, well, what is the patentee's contribution to the art? And the patentee's contribution to the art was what they claimed. It was the pure plus enantiomer. And then once it was established that this product, i.e. the plus enantiomer, was a novel product, the contribution to the art was that product, even though they only had one method of making it.
Yeah, but the reasoning in the House of Lords, which is what we need to focus on, is most clearly evident from the quotation from Lord Walker in paragraph 47, where he makes the point that a single chemical compound, which was what was claimed in Lundbeck, is a product of special character because it only has one embodiment.
Yes. Yes, I was going to draw attention to that actually. That's it's not just Lord Walker, but Lord Mance says something similar in para 49. Lord Neuberger says something similar. He says.
Yes, but Lord Walker is more precise, which is the advantage of looking at his way of expressing.
Well, it may be more precise, but I think they're all making the same fundamental point, that the claim in Biogen is, well, Lord Walker says a very large number of possible embodiments as opposed to single chemical compound. True. As Lord Neuberger says, Biogen is not a simple product. It's actually a product identified partly by the way in which it's been made and partly by what it does. So you see at the end of the quote.
Well, can I be clear? Is it your submission that there's a divergence of view between Lord Walker on the one hand and Lord Mance and Lord Neuberger on the other hand?
No, there's no divergence. It's just different ways of looking at the same thing and saying why the Biogen claim is unusual.
Right. Well, that's true, but that's not what I'm asking about, because what I'm asking about is the claim in Lundbeck. Now, you rightly say that there is a difference in language between Lord Walker and Lord Mance and Lord Neuberger. And the question I'm asking is whether that is a material difference. Because if you accept that Lord Walker's formulation is shared by the other members of the panel, then fine. The fact they may have expressed themselves differently doesn't matter. But if you're submitting that the difference in language is material, then I need to know.
Well, they're describing the claim in different ways. They're drawing attention to different ways in which the claim is unusual. And
I'm sorry, but the claim in Lundbeck was not unusual. It was a claim to a single chemical product. And that's the key point that Lord Walker is making. Because it's a single chemical product, it only has one embodiment. Whereas, although one may understand Lord Mance and Lord Neuberger to be making the same point in different words, their language is not quite so precise. And the question, therefore, I'm asking you is, do you accept that the imprecision of language of Lord Mance and Lord Neuberger is immaterial? They are saying the same thing, albeit in less precise words.
well, I'm not trying to be difficult for the sake of it, but I'm not sure they are actually saying the same thing in different words.
Right, that's the point of the question.
Yes.
So, I think what we've now established is you're submitting that there is a material difference. In which case, where is the ratio in your submission?
The ratio of
Of Lundbeck in House of Lords.
Lundberg. Oh, well, all I need to get out of Lundberg is that the general statement made by Lord Hoffman in the first place was too widely stated. There's no doubt on that. That's why I went there. As to what the actual ratio of Lundberg is, I wasn't making any submissions about that. But it's a clear statement that the apparently general statement of principle, that wasn't supported in Lundberg, so that's not right. Yeah, so we're just going to conclude by drawing attention to Lord Justice Floyd's summary in 52. Saying Lord Justice Peter Jackson agrees with that. Well, the light of the discussion we just had, probably only need to look at a few of these. 3. In the case of a claim to a single novel chemical compound, the patentee's technical contribution is that compound. Such a claim will not be insufficient.
Sorry, can you give me the page
yes,
again?
Same page, 52 at 3. I've jumped ahead to Lord Justice Floyd's summary.
52, and I think you were reading from his point 3.
Yes.
Yes.
In the case of a claim to a single novel chemical compound, the patentee's technical contribution is that compound. Such a claim will not be insufficient if the single compound is enabled by a method and specification, notwithstanding the fact that the other methods of making it, which will be disclosed the method. For the same must be true to a claim to a class of compounds, each of which can be made by the application of a method disclosed in the specification. The main thing I wanted out of this was para 6. The reason why the claim in Biogen offended the principle was not because it had process components, but because the language of the claim was so generalised, both in relation to the manner in which the product was made and in relation to its function, that it extended to embodiments which owed nothing to the patentee's contribution to the art. And here we get the famous final sentence. A claim to a product defined by its function, e.g. any heavier than air flying machine, referred to by Lord Hoffman at page 52 of Biogen, is capable of extending to subject matter which owes nothing to the patentee's contribution to the art. Now, the reason I've spent some time, perhaps too long on this, is all I really want out of is you have to identify what the patentee's contribution to the art is. And I made plenty of submissions about what that is, which is effectively claim 1. The second point I wish to get out of it is actually quite rare for Biogen insufficiency claims to succeed. Now, that's not because they're specific to cases about DNA or biotech in any way, and they could in principle apply to mechanical patent cases. And this is, it's actually a fictitious example, the any heavier than air flying machine. But you've only got to look at that fictitious example to think, well, that's so broad. It's got to be
Sorry, you mean it's fictitious in the sense that no patent claim has ever actually done that?
I'm not aware of anyone. Was there ever a claim to a heavier than air flying machine?
Well, all the time, but it wasn't expressed in those words.
Yes. Sorry,
I mean, any aircraft qualifies.
Yes. Yeah,
and we've got plenty of claims to aircraft.
Yeah. I was thinking of a claim which literally said any heavier than air flying machine, full stop. I wasn't saying you can't get a patent for an aircraft.
Right.
And that's the point of this example. If it said any heavier than air flying machine, full stop, that would be too broad, and everyone accepts that. But I think that's the closest there's ever been to anyone succeeding in a mechanical patent case of Biogen claiming insufficiency. So, what I invite my lords to determine, and the argument failed on the facts in that case too, we say that our claim is as set out in claim 1. It's a particular arrangement of instantaneous water heater, diverter valve and outlets. That is our technical contribution. And subject to my learned friend's arguments and obviousness, this arrangement was held to be both novel and inventive. So, provided the specification allows this product to be made, which it does, that's not disputed, we would say the existence of situations in which, for one reason or another, the risk of scalding isn't important, we would say it just isn't irrelevant. It doesn't mean our claim is too broad. Our claim is as per claim 1, it's the particular arrangement of apparatus you see there. You might choose to preload it with boiling water. You might choose never to have enough power on so that it doesn't scald the user. But these are merely situations in which the particular advantage of the invention is not being used because you made a choice not to use it. Now, there's a limit to what more one can say about that. I sense unless there's not any questions, I would go on to the final topic, which is the obviousness of a common general knowledge.
And that is the final outstanding issue,
Yes.
isn't it?
Yes, that's right. Now, Now, the judge, at first instance, dealt with the issue of validity at considerable length and detail because of the main argument, which was raised then, which was all about obviousness or the plead of prior art, in particular a case called Novelty over Dealing. Now, as regards obviousness, the judge directed herself as the law, paras 100, 105 of the judgment. There's no complaint about the judge's direction of law. The complaint is just about the judge's conclusion on the evidence. And before going into detail, as my lords will anticipate, our submission is the judge's conclusion was in fact correct. But even if not correct, it was properly open to her. My lady and my lord will be well aware of the case of Fage and Chobani.
Yes, but that's not apt, is it? I mean, it doesn't matter. Fage and Chobani is about findings of fact. This is an evaluative, multifactorial decision. And so the relevant authority is ICOS in the Supreme Court, which says you need an error principle. So it's close, but it's not the same.
Yes. Well, I do want to make the point about this. The judge had a sea of evidence, whereas we're only doing some island hopping. I think that's a separate point which I can legitimately make, and that point is actually made in Fage and Chobani as well. But yes, I entirely accept my Lord Justice Arnold's point. Now, the concerns about having effectively a second trial on the facts, on appeal, are elevated where the case is obviousness over the common general knowledge alone. And I think it's the last authority I wanted to take the court to. That's a decision which Justice Bertie then would call Accord and MEDAC, and that's Joint Authorities 2, tab 8. Because there's a particular problem with arguments of obviousness over common generals alone, which is all we've got now. Now, if my lady and my lord are at tab 8, the first important paragraph is paragraph 119, page 404. And we can see from paragraph 119 it actually failed anyway, because of the territoriality of common knowledge. We don't need to worry about 119 though, that's just why it failed anyway. But paragraph 120, before leaving the argument based on common general knowledge alone, I'll mention the words which Justice Floyd then was in ratio form, and in particular the passage at 158, which warns that such attacks need to be scrutinised by care, since they can be favoured by parties because the starting point is not obviously encumbered by inconvenient details of the kind found in documentary disclosures. Respectfully agree with Mr. Justice Floyd. And the next paragraph is 123, but to get the point of 123, you need to read 121 and 122 as well. And the point made in 121 and 122 is that normally the person attacking validity will rely on a particular concrete document or well-defined prior use as a starting point. You don't need to, but that's the normal way. And 122, many inventions involve a combination of known features. However, a combination of features, all of which individually were common general knowledge, can give rise to a valid patent claim if that combination is new and non-obvious. Patent trials are inevitably ex post facto, and a key problem is to identify and avoid hindsight. Combinations of features can pose a particularly acute hindsight problem. The thing about concrete items of prior art, whether they are prior published documents or prior used products or processes, is that whatever combination of features that concrete prior art consists of is not one which is created with hindsight knowledge of the invention. That leads on to 123. The problem with arguments over common general knowledge alone is that the combination of features relied on is always and necessarily one created with hindsight knowledge of the invention, and worse is one which the person attacking validity has not been able to find as a pre-existing combination in the concrete prior art. If they had, they would have relied on that concrete prior art. Either the combination has not been made in the concrete prior art at all, or it only appears with additional inconvenient details. If an invention is not obvious or with a concrete prior art relied on, the court is entitled to be sceptical that an argument that nevertheless obvious or with common general knowledge of the law is correct. And the facts of that case don't really matter, but towards the end of the next paragraph, what the party attacking validity had done was create an amalgam of the best bits of the two cited documents. That was a good way of getting rid of the inconvenient details. Now,
So where are the inconvenient details in Dealey?
oh, well, I mean, I could tell you, but it was the mixer shower system for a start. The cross-reference to McMaster Christie wasn't one that the defendant's expert got correctly. It wasn't a combination he was able to explain how to make. There was all sorts of reasons as to why the prior art case failed over Dealey. They're all set out in the judgment. I can go through that, but that's not appealed against. I think the number one inconvenient details was that Dealey was a mixer shower. Now, the case on obviousness is very much phrased on, oh, it's a commercial idea. Now, that's just their assertion that it's a commercial idea. They keep using the word commercial as though that's the trump card, that's the answer. All you've got to do is call it commercial. But our expectable vision is not just a commercial idea to produce a dual electric outlet electric shower. The claim is not, let's market the claim devices at a price which is 10% lower than the competition or via some new retail channel.
So your submission is that the invention is having the idea of a dual outlet electric shower.
Well, I'll come to that. It's all set out in the judgment, and our submission was accepted. But yes, it's appreciation of the problem and solving it.
No. Let me ask my question again. Is it your submission that the invention is having the idea of a dual outlet electric shower?
No, it's more than that. That's part of it, yes.
It's more than that.
I will do it, and I will design it in a way as per the claim.
So you would accept that just having the idea of a dual outlet electric shower is not an invention. You need more.
I'm not sure I would accept that. What I'm saying is...
Right, so in which
say it
case
is more.
your submission is, it is an invention to have the idea of a dual outlet electric shower.
Well, I don't shrink from saying that, but I'm saying that's not actually my case.
So, to be clear, you say, if necessary, that is an invention, but you say you don't need to go that far.
Well, I don't accept the idea, the principle that an idea for a product can't be invented. If that's underlining it, oh, it's just an idea. It seems to be implicit.
No, that wasn't the question. The question is specifically this idea, a dual outlet electric shower. And at the moment, what I'm writing down, and if I've misunderstood, please correct me, is you, if necessary, you say it's not necessary, but if necessary, you go so far as to say that the idea of a dual outlet electric shower in 2008 was inventive per se, but you say you don't need to go that far.
No, I don't need to go that far, but even that's not actually an accurate... I wouldn't say dual outlet electric shower full stop. I would say the invention as per claim 1.
But of course, claim 1 doesn't have a shower in it at all, so that doesn't really help.
Yes, no, well, that's a different point. Lord's right on that. But Lord's formulation of the question is actually taken out the diverter valves configured so flow rate is substantially unchanged. That's our characterising clause. I think the way my Lord was putting it is, didn't have reference to characterising clause. So I would say, well, no, that's the idea.
So we go round in circles.
I'm not sure we are going in circles.
It doesn't really get you anywhere. So you effectively say the idea is thinking of the diverter valve.
Well, it's a bit more to it than that.
Rather than a marketing department wanting to sell a dual outlet.
I do say it's the technical idea, yes, rather than the marketing department saying we quite like this sort of product. But it is the idea of having an instantaneous water feature as per claim, which has the the characteristics of claim 1, that having that idea, and then providing it. In order to provide it, you've got to realise, there's this problem about the risk of scalding during changeover, therefore I've got to solve that problem. And it's a problem which arises for dual outlet electric showers, but not for single outlet, because they don't have changeover. Now, and I think I can legitimately say that if it was just a claim for a mere idea, it's a little bit surprising that there wasn't better prior art than there was then. And my own friend's having to rely on his hindsight selection of common general knowledge. But let's look at some findings of fact made by the judge. Now, where this is leading to is where she deals with the argument of obviousness of common general knowledge itself, but there was a number of findings of fact made along the way which are relevant to that. And we respectfully invite the court to go back to the judgment. And it's paragraph 26 on page 108. Now, the reason I'm going to this is Mr. Mills, who was my client expert, didn't accept the patent as obvious of common general knowledge. It was Mr. Murray who did. Now, ultimately, it's a question for the court, obviously, but it's to be made on the basis of evidence. And the number of findings of fact made about Mr. Murray's evidence, which this was the first one. Now, point of para 26 is about Mr. Murray reading the pleaded prior art, which was Dealey and McMaster Christie. And then reading on to the bottom of this, 3 lines up to the bottom, in cross-examination he said he was told that Triton was attacking validity of the patent. The case was about multiple electric showers, multiple outlet electric showers, and he assumed that meant the range of products included a diverter valve. He said that Triton solicitors had provided him with both Dealey and McMaster Christie, and he read them with a particular focus on the fact that Dealey had shown multiple outlets and a diverter valve, and that if he'd not been told about the importance of multiple outlets and diverter valve, he would not have focused on these elements. Now, this goes to how he was instructed about prior art which is no longer relied on, but he was told right from the outset and given hindsight knowledge of what the case was about. It was about multiple outlets and diverter valves, so he was primed, as it were, to the importance of those topics. Now, there were some other points on which Mr. Murray was criticised. 27A isn't important, we're not going to look at that. 27B is a little bit more important because my own friend made a point about the Bathroom Manufacturers Association. This actually came in as an answer to Mr. Murray's evidence in support of obviousness, because what Mr. Murray had said is where the shower head was to have an adjustable spray pattern, it had to be designed so it was never possible to position the adjuster in such a way the flow of water was obstructed. Some shower heads might obstruct the flow during adjustment or even have a dedicated button to temporarily cut off the flow. If these kinds of shower heads are sold as separate items, they will be prominently marked as not being suitable for use with electric showers. That was the emphasis in the original. And that was why we came in with the Bathroom Manufacturers Association report, which post-dated as evidence to say, well, no, that's not right. They're not being prominently marked as not being suitable for electric showers because the Bathroom Manufacturers Association are having to warn that people are not doing exactly that. Now, my own friend spent a bit of time on it. We're not saying it's the be-all and end-all to the case, but it is significant that even after the patent, people still weren't realising that there was a particular issue with electric showers. I should probably show the actual... did he show it? I should probably show the actual publication in question. I won't spend too long on it, but I'll just show you. It's subpad bundle, tab 14. Page 127. And the point was, only a few points on this. 29th of January 2024, so as late as that, the BMA, and it's the Bathroom Manufacturers Association, not the British Medical Association, is issuing this urgent safety alert. First full paragraph, last sentence: electric showers represent around half of all showers in the UK. Third paragraph from the bottom: the BMA is concerned that too few suppliers of start-stop button shower heads are providing clear warnings not to use their products with instantaneous electric showers. So this actually came in as an answer to one of Mr. Murray's points, relied on the support of obviousness. But we say it's still significant that even that late, it still wasn't generally recognised that there was a problem with stop-start buttons with instantaneous electric showers.
Sorry, can you help me? I'm struggling to understand the relevance of this to the obviousness question. I mean, first of all, this is, 16 years after the priority date or something? Secondly, this is about stop button shower heads.
Yes. Yes, well, the point is, even though it's so long after the priority date, people still don't seem to appreciate the safety risk, even now.
Of a stop button shower head?
Yes, but the risk arises because of the interruption to the flow of water over the electric heaters. It's the same way the problem arises.
Right, okay.
And then moving on with, the only point in para 29 of the judgment is Mr. Murray failed to acknowledge no dual-out electric showers in the UK market. And moving on to 30, the commercial barriers. The way this came into the case, as we see from para 30 of the judgment, is, again, it was the other side's answer to our case. They produced this evidence from Mr. Murray that apparently there were and are certain commercial barriers to selling electric showers in multiple outlets. We didn't ask them to produce that evidence. There was something they chose to produce. And then both of these points fell apart in cross-examination, as the judge says more than once. There never were any commercial barriers to selling electric showers in multiple outlets, even though Mr. Murray said there were. And we don't need to go through 31 to 34, but there's a number of other problems with Mr. Murray's evidence, even though he was the witness for obviousness over common general knowledge, and even though he was primed by his instructions as to what the important issues in the case were. Now, moving on to judgment, paragraph 97. This is the evidence. My Lord Register General says, well, what was the inconvenient detail with dealing? Well, this is part of it, last sentence of 97. Simple fact is that use of a diverter of an electric shower had not been disclosed in the 30 or so years since electric showers became commonplace in the UK market until the patent was filed. As I said earlier, Dealey was the mixer shower. Right, moving on to 106, I will just draw attention to 106, because that is actually our position on inventive concept. So I'll outline it. Last sentence of 106. We don't have any other submission. This is our submission as to where the invention lies. It's the perception or the appreciation of property that having a diverter valve in a dual outlet electric shower can give rise to a risk of scalding, and in overcoming it. That's what we say the invention lies in.
And can you help me on this? How does this work at the level of Claim 1, which you accept is not restricted to showers or indeed products that are necessarily intended for use in contact with human skin at all?
Yes, the obviousness of a common general knowledge case was also based entirely on showers. It wasn't based on anything else.
Right, but I get that, and hence the questions we were talking about earlier, but I'm still not understanding what your submission is as to the inventive concept of Claim 1. Because you say here that this remains your case on the inventive concept. What I'm struggling with is that you're relying upon an inventive concept which is restricted to an electric shower. And how does that work in circumstances where Claim 1 you accept is not restricted to an
Yes,
electric shower.
that's a fair point, my lord. We've used the word electric shower there because that was the nature of the argument below. But my lord is saying we should have said dual outlet instantaneous water heater. That can give rise to this.
But how is there a risk of scalding if there's no human skin involved?
Well, there still is if you use it as an ablutionary apparatus, yes.
Right, so your submission is that we read into Claim 1 that it's ablutionary apparatus?
No, I couldn't do that because it doesn't
Right.
say that.
Okay, so what is the inventive concept of Claim 1?
All I can say, I mean, I accept the correction. I've got to, well, the way we put it here was a dual outlet electric shower for the reasons already given. That was the way the argument ran. But we'd have to say it's a diverter valve and a dual outlet instantaneous water heater. An electric shower is only one example of that. We'd say it's the prime example of it.
Do you say it's something that would, if exposed to skin, otherwise give rise to a risk of scalding? Just what?
Well, that's what I say the words mean, yes. That's why, that's how I say
Even if used in an environment where there would in fact be no risk.
yes, but that's because I say that's the way you've chosen to use it. It comes back to what do the words mean? You've got to give the words a meaning. And if I'm right about risk of scalding, that's what they mean, and they don't change their meaning because of a different context. They might just cease to be applicable to the new context, but they don't change the meaning. Now, then we come to the assessment of the judge's evidence over common general knowledge alone. Yes, it's here. Yes. Now, our formulation of the inventive concept was supported by Mr. Mill's evidence. You can see that from paragraph 107. And over the page at 145. Mr. Mills says, I thought it was a neat and useful way to achieve the aim of not scolding the user. Now, as with construction, Triton didn't plead to the inventive step at all. And then when we sent an RFI to them, they just repeated the word of the claim, which they said had no meaning. Now, Judgment 110 sets out the arguments of the judge, but all these show is that some items of information relating to the patented invention can be found scattered across the prior art. It doesn't say anyone would have put these things together. Now we'll come to the evidence about did Mr. Murray say you could put these things together. But at the moment these are just the individual items devoid of any particular context. It's not a combination that has been made in any concrete document. Now, the judge then deals with the Petra Fisher case, and my friend did go to it briefly. I'll try and do it even more briefly. Well, no, I think I need to look at it. We would say the Petra Fisher case, which the judge just deals with, is not establishing any principle of law anyway. It's just a particular result on different facts. And the judge has two reasons for it, but we should probably just look briefly at Petra Fisher, Joint Authorities 1. And it's really just the last page of it. Page 9. Last three paragraphs, the decision of Mr. Justice Jacob at first instance. And line 16, it is suggested that this is a particular article, this is a technical prejudice against anyone having an idea of putting a diesel engine in a cabriolet, and that therefore the idea should be regarded as invented. I do not agree. So there was no evidence of any sort of technical prejudice or mindset. Towards the end of this paragraph, as a matter of fact, because he talks about the patent, well, he says talk about the patentee and her patent, then he says he. As a matter of fact, he knew already that you could put any engine that will work inside that engine space, and this is simply telling you could put in a diesel. That, to my mind, is not disclosure or invention of any kind whatsoever. And then, last full paragraph, Ms. Victoria says, but the skilled man would never think of this idea in any shape or form. I do not agree that's so at all. He would consider as a matter of common sense. I think this is the kind of case where common sense can be applied, that you can drive a motor car with any kind of motor that will work. And that's all we have here. So it's really quite different facts. And the key thing is, you can drive a motor car with any kind of motor that will work. So it's just a drop-in replacement. And it's a matter of common sense. There's no prejudice against it. So really, I don't see there's very much in Petra Fisher that takes us anywhere. And if we return to the judge's judgment, so 113, the judge says, well, she doesn't agree with the characterisation anyway. But also, if we go to the end of 113, I also accept Mr. Campbell's submission from Meyer and Petra Fisher. There's no evidence of technical prejudice against the idea of diesel can be labour. In this case, I have the experts' agreement that mixed showers and electric showers are fundamentally different. In principle, Mr. Mill's evidence that each require a different mindset, which I accept. So these are various findings of fact which are all leading up to common general knowledge, and in particular the judge's finding on that. The judge deals with various points over DELI. It's DELI and plus common general knowledge is next section. But common general knowledge alone starts at 121. And 121 concerns simplicity of the solution. 122 is obviousness with the benefit of hindsight. Now, my own friend spent some time on Haberman and Jackal. The facts obviously are different. There's no doubt about that. But the point the judge is making is really the second line on page 150 in view of the obvious benefits which would flow from it. And that's taken from Mr. Justice Lavier, Haberman and Jackal. And the point here is that there would have been obvious benefits which would flow from the invention in this case if it had been done earlier. And then we come to the crux of it. Para 124. Mr. Murray's evidence about obviousness with a common general knowledge, in my judgment, highly confused. And this is the evidence which is said to land it for the appellant. So going through this highly confused evidence, in his report he asked himself whether it would have been obvious to the skilled addressee at the priority date to make a claimed water heater with a diverter valve downstream of the heater tank to direct water to at least one outlet from at least two outlets. But as Mr. Campbell put to him in cross-examination, he accepted he didn't answer that question. Now, if it really was obvious, that's where he would say, yes, of course it was obvious, but he didn't answer the question that Millennium Friends is inviting my ladies and my lords now to decide. He simply said the choice of the number of outlets would be a commercial marketing decision, and says, I do not think that the skilled addressee see any technical reason not to attempt to make a multiple outlet electric shower. So we've got the double negative there. I do not think that a skilled addressee would see any technical reason not to attempt. This does not address whether it would be obvious to the skilled person. He would not be drawn on this. When asked if there was any technical reason why the skilled addressee would attempt to make a multiple outlet electric shower, he said if the skilled addressee was instructed to do so, he would make an attempt based on diverter valves that already exist and instantaneous electric showers that already exist. When asked whether if the skilled addressee was not instructed to do so, it would not be at all an obvious thing to do, Mr. Murray confusingly said it is not a case of obviousness.
Yes, well, because Mr. Nicholson's submission is that's all about the marketing brief, which of course is outside his sphere. The marketing brief is where he starts from.
Yes, well where is the high point of the evidence for Mr. Murray, the witness on this point, to say that it is obvious? The judge is dealing with the evidence and saying it's highly confused. In my submission, it is. It's rather like a case I did quite a time ago, Stena and Irish Ferry. It's all about the winning point in that case was we looked at the patentee's witness and asked him whether, was it obvious or not, and it was a somewhat unconvincing answer. I think it was my Lord Justice Arnold was in that case, and he was the one who got the answer, so he may remember the incident. But the The point about here is Mr. Murray was all pumped up by, he'd been primed as to what the important issues of the case are. He was asked the direct question, and he gives these confusing answers, and no direct answer as to why, well, why would it be obvious? But this is the high point. There isn't another high point in this. And if it's as easy as my learned friend says, why could they just not go to the high point of Mr. Murray's evidence and show my ladies and my lord where that is? Now, Para 125 is the cross-examination of Mr. Mills, but he maintains his position under cross-examination. It's set out in quite some detail. This is the cross-examination of claimant's witness, Mr. Mills. And it's all along the lines of, well, it'd be fairly obvious to do it, wouldn't it? But going halfway down 125, second whole page, he did not agree, the skilled addressee, who, I remind myself, is not invented, would take a diverter valve from a mixer shower, an instantaneous water heater from an electric shower, and create a dual or multi-outlet electric shower within claim 1. That's fairly clear evidence the other way. And then there's quite a detailed quote. He said they would take an electric shower, look at what bits they could reuse from electric shower, if any, and take it that way. Likewise, if they were designing a mixer shower, they would look at an existing mixer shower and take any bits they could reuse or ideas or concepts from that. To my experience and understanding, there is next to no crossover between the components of the electric shower and the mixer shower. An electric shower is typically made of molded plastic components. It might have a metal heater can, it might have a plastic heater can, whereas a mixer shower is typically made of brass or some other similar metal, and with either ceramic valves or mixing valves, etc. in it. They are very, very different products, and there is next to no crossover within the engines of the body. His evidence was that an engineer would look to design a rough prototype from scratch and then perhaps 3D print some machines. However, you might pick up a component from the mixer world off the shelf, more to see if it did anything, but I think in terms of demonstrating a product, as you were developing electric shower, you developed something new. So he is cross-examined at length about this, and he's consistently making...
Can you help me on this? Does the witness, I mean, I can't see it in the passage that's quoted, but did he anywhere else give an answer to the question of what else you would use to have a dual outlet electric shower other than a diverter valve? I mean, at the moment, I can't see that there's any alternative, but if he did suggest an alternative, then could you direct me to the evidence?
I don't think so. I don't think any alternative was put to him. And I don't think he said it either.
Right. So, if there's no alternative, it's what the EPO calls a one-way street, isn't it?
Well, if you have the idea of going down, yes, then that's the whole point.
So it comes back to the invention is the idea of a dual outlet electric shower.
Well, no, it's I'm going to repeat myself. It's not. It's more than that. Just take it on. Yes, actually, there is a point. It's not an answer to the question, but I'll just ask it. It's 42. Yes, actually, I think we did look at this earlier today. On page 116, it's 42, 13, 1 and 13. Yeah, I mean, this is all about mixer showers at the prior date. One sees that from prior 42 in the previous page 115. But 12 and 13 dual outlet mixer showers were commonly available on the market in the UK, and 13 at least some of the diverter valves incorporated into mainstream mixer shower products at the priority date would have affected the flow rate during changeover, including the Mira Montpellier mixer shower. So it's not as simple as, oh well, let's just get a diverter valve from a mixer shower, because you've still got to think about how the flow rate is affected. But going back to where I think it was just about finished anyway with that bit. My point is that the judge has seen both witnesses and assessed their evidence, and the claimant's expert witness maintains his position with reasons under cross-examination. And he's making the point, and just to stress 2 points in that rather lengthy paragraph I just read out, he didn't agree that the skilled addressee would take a diverter valve from a mixer shower, an instantaneous water leads from electric shower increase of dual and multi-outlet electric shower within claim 1. And that, in a sense, is the amalgam that my learned friend is trying to aim at. Didn't agree with that. And then when it was put to him, oh well, if you're going to do it, then you'll have your rough prototype and 3D prints, and then it's a one-way street. He says, no, as you're developing electric shower, you would develop something new. So he's not saying it's an obvious thing to do. So that was the evidence, and the judge was entitled to reach the conclusion that she did. Put another way, if it really was obvious over common general knowledge, the party attacking validity would have had a much easier and better and more convincing case than they ended up having, rather than having to rely on confused evidence from Mr. Murray. If I could just take a moment just to check. Thank you very much for your indulgence. These are my submissions.
Thank you very much indeed. Mr. Nicholson?
My lady, my lord, I've only got a very small number of points in reply, and I'll try and take them quite quickly. The first point, I'll take them as they arise in the order of my learned friend's speech, if I may. The first point which I wish to make a few observations on is the meaning of unchanged in claim 1. And the surprising contention from my learned friend that unchanged is now limited to reduced, so that one doesn't reduce the flow rate and therefore end up with an elevated temperature. As has been discussed, the principles of construction are why the ones look at the ordinary use of the ordinary English words in the claim. Unchanged clearly has both directions open to it. And the same arises in the passage at the beginning of the patent, where the patentee is concerned to avoid sudden unexpected changes in temperature. It is either way round. My learned friend's fixation on scalding is simply to arbitrarily find a reference which is nowhere to be found elevated to the test for the standard in the claim anywhere in the body of the patent. Moving on, or staying within the elms of construction, my learned friend made a number of submissions about hypothetical examples. I'm not going to add further to what has already been discussed with the court as to the pleading point and the like. We say it's fully adequately pleaded. What my learned friend ended up saying is he accepts that hypothetical examples can be run to the extent that they're worked out examples. I would caveat that to the stage if they have to be sufficiently worked out examples for everyone to know what we're talking about. And the whole point about the dishwasher is a machine that you can't access the water. It's as simple as that. Now, you can add on extra details if you want to for way of illustration, but what we had in mind was two different spray outlets, top tray, bottom tray in the dishwasher, and a solenoid operated valve, which is not excluded by the claim, to allow in the middle of the wash process the water nozzles to be moved from upper tray to lower tray and backwards and forwards and the like. The key characteristic that everyone can engage with is some machine where you've got heated water and you don't need to touch it. I'm entitled to do that, and I have. Likewise with the pressure washer, the point that was being made about the heated pressure water, and one can easily envisage a scrubbing nozzle and a spraying nozzle, for example. The point was temperature that can go way above scalding temperature, so way above 55 degrees centigrade, in circumstances, again, where the user wouldn't touch it, although they could touch it. Those sort of examples we use routinely in testing patent claim constructions, and I don't accept that I'm outside of my pleading in respect of those. The ground 2 and the Schrodinger's patent infringement, as we somewhat put it, I struggle to follow what my learned friend was saying as to the bounds of the claim and what one is and isn't allowed to do with the diverter valve. It appeared to be, as we have long suspected, that you cannot look at the valve and say this valve that the skilled person has in an instantaneous water heater infringes or doesn't infringe. My learned friend takes the position that one has to consider whether it's going to end up in a shower or a piece of farm machinery, whatever it might be. So that when those self-contained and boxed up Acme general purpose instantaneous water heaters with diverter valve appear at the border, it is impossible to determine whether they infringe or not. And we say that isn't a proper approach to construction of the claim. On ground 3 and moving on to infringement, my learned friend is very excited by marketing material that extols to the end user seamlessly divert, but no attempt, save for with the witness discussing what we might mean, was made to put any bounds on that. As my ladies and my lord almost certainly know, it's an important part of patent cases that there is a proper description of the alleged infringing product. And for that purpose, we routinely produce product and process descriptions setting out the bounds for the case. Indeed, my clients were ordered in the usual course to do so in this case. The second issue that arises with product and process descriptions is an express part of the provisions under Part 63 that the person making the statement positively acknowledges that they must make themselves available for cross-examination at trial if requested by the opposing party. The whole point of that is to ensure that there isn't spin, there isn't marketing puff or anything in the product and process description, that it is an accurate collection of all the information the court needs to determine the question of infringement or not. And if the claimant, the patentee, has any reason to require extra clarification as to the operation of the products for the purpose of their infringement case, then they either ask for further information in the product description before trial, or they require the signatory to turn up. And it could have been explored the extent to which the marketing materials truly reflected the technical operation of the product. We respectfully say it's not appropriate to allow the product description to go through, not find what you want for your infringement case, and then start making submissions to an expert about marketing materials without even showing them those materials in the hope of gathering information about the technical operation of the product. There's a slight correction as to what my learned friends portrayed in terms of the path to ending up in an infringing product. Technically, it is irrelevant what the path is to assembling the entire overall shower. But my learned friend did portray it as putting in the diverter valve and then adding the flow stabilization valve as a sort of combination exercise. What the judge actually found in, I think it's 44.3, is that flow stabilized, and my learned junior will just find that reference for me, is that pre-existing electric showers already had flow stabilization. They were already there, and the diverter valve has been added to a shower that already had flow stabilization. So it isn't a combined exercise of trying to design flow stabilization diverter. It's more, as my Lady Justice Falk suggested, that in the existing electric shower there wasn't a problem when the diverter valve was added. The diverter valve had to deal with. It's judgment paragraph 43, little Roman 3 and little Roman 8 for those findings on the FSV. That moves me to validity, and fuzzy boundaries. I don't think I take issue really with anything my learned friend has said about the law. And indeed, I briefly addressed my ladies and my lord on consisting essentially of and touched upon the issue of fuzzy boundaries. I thoroughly accept that a claim is not invalid insofar as you end up with the fuzzy boundary, the small area of the claim that the court has to agonise over in circumstances where there's a particular issue with infringement or a particular issue with prior art or some form of attack. The distinction between uncertainty, insufficiency, and mere fuzzy boundaries is one where you really cannot ground the claim at all. You simply don't know where to start. And the case that my client makes in respect of substantially unchanged is we don't know whether we're even looking at 1%, sub 1%. I've really struggled personally with anything of a movement of more than 50%, because then there's more variation than lack of variation, if that makes sense. But I certainly go down to 50%. But we know my learned friends go even further. They go down to 66% variation, and then a further consideration has to be brought in with, well, in the context of the system as a whole, outside of the bounds of the actual apparatus claimed. And the result is, where a manufacturer is sitting with an instantaneous water heater and a design of a diverter valve as a combination within the bounds of Claim 1 on their desk, they simply do not know what they're looking for substantially unchanged. Is it basically unchanged but with a very, very minor, 0.5%, 1% or so that might put you in the fuzzy boundary issue? Can you push it down to 98%? Or is anything down to 50% or 60% or more permissible, depending on either the apparatus or some form of subjective intention as to how the equipment is subsequently to be used? I respectfully say that is gross insufficiency, and it's of the type to give rise to the uncertainty which my client contends for. That then also brings me on to the Biogen issue, the Lumbeck issue, and the scope of claim. To be clear, we are not in a Lumbeck type scenario. A Lumbeck type scenario is where you have a claim to a specific single molecule. There is only one molecule, there is only one way of doing it. It isn't often characterised this way, but one of the inherent features of a mechanical or electromechanical invention is it's always claiming a class of apparatus. There is more than one way to make a piece of apparatus that satisfies the requirements of the claim. It is far more like a class pharmaceutical claim, where rather than claiming a single molecule, one is claiming a number of different molecules, all of which have a particular functional group or something of that nature. So we are in the class scenario, and the question arises, does the class, remembering that this is on the judge's construction, extend well beyond the patentee's actual contribution? And if the judge is right, and this claim covers any way to make a dual outlet electric shower or instantaneous water heater, that goes well beyond any technical contribution made by the patentee. And in fact, it's very akin to the example that my learned friend scoffed over, which was a claim to all heavier-than-air flying machines. He hasn't got a claim to all heavier-than-air flying machines, but he has got a claim, he says, is paragraph 59 of his skeleton, to all dual-outlet electric showers, no matter how made. Oh, sorry, which do not scold the user, my learned junior rightly corrects me. That do not scold users, no matter how implemented. It is absolutely the classic example of an overly broad claim. As I say, that arises on the judge's construction. That problem doesn't arise on my own construction. Then finally, we come to obviousness. I do take on the head, as of course I have to, that one has to be careful with CGK loan attacks. They are open to abuse and shorn of details in the matter. But the scenario that I have posited is one which is very simple. My learned friends have not identified what inconvenient details I have shorn. I've started with a marketing brief of a request for a dual outlet electric shower. Actually, I don't need to prove it, but very easy to conceive. A customer walking in and saying, I want that shower arrangement, please, but I can only have an electric shower. One can quite understand how marketing would come up with such a request. And then what does one do? All that one does is add a diverter valve, just like you have in a mixer shower, to the output of an electric shower. And the evidence that we took Mr. Mills through, that's my learned friend's evidence, is saying, well, what happens when marketing asks that? And he did balk slightly about whether marketing would answer it, but eventually he went along with the assumption. And I suggested to him that he could use a valve from a mixer shower, and he balked at that and said, I don't really want to use any components from the mixer world. I'd rather design my own and 3D print it. Fine, but you don't have any problem with that. No, he doesn't have any problem with that. And he would either then come straight within the claim, or he accepted that if, when he turned the system on, he had big changes in temperature, he would know exactly why and exactly how to fix it. And I would encourage, given what my learned friends have said there, my ladies and my lord, just to read that relevant part of the cross-examination. It's in the supplemental bundle, tab 9. It starts on transcript page 45, line 14, and it runs through. I think, to the top of transcript page 68. That is Mr. Mills's evidence, and I say it gets me home. I also say that Mr. Murray's evidence one has to be a little bit careful with, because my learned friend is keen to rely on the results of cross-examination rather than the direct challenge of what Mr. Murray said clearly about his case, which wasn't properly challenged. It's in the supplemental bundle at tab 3. It's paragraphs 113 to 116 of his first report. And my ladies and my lord will also want to look in tab 4 at his reply evidence at paragraph 22, little 2. And that, we say, wasn't ever properly challenged in cross-examination. So that is obviousness, subject to anyone behind me. Any questions that my ladies or my lord may have, those are my submissions.
Thank you very much indeed.
I know I don't get a reply speech. I've just quickly checked some of these references. I don't think they deal with claims 4 and 17. I think it's just claim 1. But having said that, I'll now sit down, and thank you very much.
And I reply and say the same matters arise time and time again. Claim 4 is simply do not shut off at all. We say that there is no technical difference. You've already realised don't reduce the flow rate. There cannot be an invention in completely blocking off the channel. And 17 is, 17 is no more than 2 outlets. If you've had add to the marketing idea, I would like some side jets too. Skilled person has absolutely no technical problem in delivering. Apologies, my lady.
Thank you very much, and thank you to everyone, and thank you to those who haven't spoken today, but no doubt have done an enormous amount of work. We're grateful to all of you. You'll be glad to know that we're going to reserve our judgments in this matter, and we'll deal with them as quickly as we can. You'll be extremely aware, very aware, of how we deal with matters in this court. Drafts will be circulated. They will be subject to an embargo, which we take very seriously. So please, if you need to include someone else that you haven't given details of already, don't just do it to come back to us, please. And you'll also know that we are grateful for corrections as to our grammar and our spelling, etc., but not any kind of re-argument. And that we also hope that you will be able to agree a consequential order once you've seen the judgment. If you can't, very short written submissions, please, and we will decide the matter on paper. Thank you very much indeed.
Shall we return the valves?
It depends whether or not it will be of assistance to my lord. If you wish to hold on to them, you're more than welcome to do so.
Thank you.
Right.
I will treasure it. Thank you.